Good morning, ladies and gentlemen. Welcome to the 2022 Annual Conference of In-House Lawyers Committee of the, organized by the In-House Lawyers Committee of the Law Society of Hong Kong. I'm Joanna Tong, the MC of today's event. Before we start our program today, I have a few reminders for today's participants. Today's conference will be divided into the morning and afternoon sections. The morning section will run from 9:30 a.m. to 12:10 p.m. and carries 2.5 CPD points. The afternoon section will run from 2 p.m. to 5:25 p.m. and carries 3 CPD points. Please refer to the conference brochure for the program rundown, course outline, and profiles of our panelists today. For those who are joining both sections in person, please be reminded to sign in for both morning and afternoon sections in order to claim your CPD points. There will be a short break for each of the sections and a lunch break from 12:10 p.m. to 2 p.m. between the two sections. Owing to the public health condition, eating or drinking is not allowed in the conference venue, and please make your own lunch arrangements. You are also reminded to put on your mask at all times and maintain social distancing in the conference venue at all times. The conference will be conducted in English and Mandarin, and supported by simultaneous interpretation in the two languages. We have some devices for participants joining us here in person, which will be provided on a first-come, first-served basis. Users may select channel 1 for English and channel 2 for Mandarin. Please contact one of our staff members if necessary. For our Zoom participants, you may mute the original audio and select the audio channel from the control panel at the bottom to listen to the conference in your preferred language. Please turn your mobile phones and other sound-emitting devices to silent mode. You will be given a name badge when you enter the conference venue. Please carry it with you at all times during the conference to allow our staff to identify you and to provide necessary assistance. You are welcome to raise questions at the Q&A sections arranged at the end of every panel discussion. For those of you who are joining via Zoom, please use Zoom's Q&A function. Panelists will address your questions if they see fit. Welcome again to the 2022 Annual Conference of In-House Lawyers. The conference is organized by the Law Society's In-House Lawyers Committee, supported by the Department of Justice as supporting organization, and sponsored by our platinum sponsors, including Dongguan Lawyers Association, 东莞市律师协会, LexisNexis Legal and Professional, Link Asset Management Limited, Wheeler Legal, as well as our gold sponsor, Hill Dickinson Hong Kong. May we now invite Mr. Siam Chan, President of the Law Society of Hong Kong, to give us a welcoming speech. President, please.
Distinguished guests, ladies and gentlemen, it is my great pleasure to welcome all of you today at the Justice Place to the 2022 Annual Conference of the In-House Lawyers of the Law Society of Hong Kong. May I first express my sincerest gratitude to the Department of Justice for being a supporting organization of our conference and providing this prestigious venue for the conference to be held physically this year. In fact, for those of you who are familiar with the governance structure, this building used to be, before the handover, the Executive Council with the Governor. They held the Executive Council meeting in this very building. So it's a very prestigious venue. For the very first time, our annual conference is held in a hybrid mode with almost 1,000 registrants joining us here in-house or online, including our members and our counterparts from the Greater China region. This record high registration number and the fact that our around 5,000 members who are not in private practice are now representing over close to 1/3 of the Law Society's membership, which is now close to 13 thousand shows that in-house lawyers are an important and substantive force in the community. So almost 1/3 of our members are now working in-house. I was the first chairman of the In-House Lawyers Committee, which was formed in 2011 to serve this increasingly important community. There is no doubt that as the population of the in-house legal sector increases, the role of an in-house lawyer has evolved over the years. Rather than only managing the legal risks associated with the business that they work within, an in-house lawyer may also be required to partner with the business, understand its issues, and produce viable and tangible solutions to support all the business functions. The involvement of in-house legal teams in different aspects of business operations has become more active and crucial to the business. In challenging times like the ongoing COVID-19 pandemic, in-house lawyers often find themselves at the center of the company's operation, connecting different teams of the company, addressing high-stakes questions from time to time, in addition to regular legal matters. In-house counsels are often required to step out of their legal mindset and contribute to a broad range of other board matters. In fact, we have a session this afternoon to talk about whether in-house counsel should be given a board seat. To cope with the extended roles of an in-house lawyer, establishing close working relationships with external lawyers is also crucial for in-house legal teams. These challenges and opportunities will all be explored in depth by our speakers in our conference today. Since last year, we have invited our counterparts in the Greater China region to join our conference, where simultaneous interpretation has been arranged to accommodate participants from a different jurisdiction. This year, we have further invited speakers from the mainland to join one of our panel discussions to share their experience in cross-border collaboration. The session will be conducted in Mandarin and simultaneously translated into English. I hope that our conference can continue to expand to allow more opportunities for legal professionals from different backgrounds to exchange ideas and connect with each other. This year marks the 25th anniversary of the establishment of the Hong Kong Special Administrative Region, as well as the 115th anniversary of the Law Society of Hong Kong. We were established in 1907. So it's our 115th anniversary. In celebration of this historical moment, the Law Society has organized and will organize a number of activities, including today's conference, and I'm grateful for the generous support received from the Department of Justice. To kick off the afternoon session of today's conference, the Secretary for Justice, Mr. Paul Lam, will grace us with his keynote speech after the lunch break, so do return. And I very much look forward to benefit from his insights. On this note, I would also like to thank all esteemed panelists and participants who join us today, all our sponsors for your support, and the In-House Lawyers Committee for putting together this program and connecting all of us here. May I finally wish you a fruitful conference. Thank you.
Thank you, President. Without further ado, we would like to introduce our first panel of today. In this section entitled Balancing Data-Driven Marketing and Sales with Data Privacy, our speakers, Mr. Aaron Blaisdell, Managing Associate General Counsel, Head of Data Privacy Legal, Asia Pacific HSBC, Ms. Ada Chong Lai Ling, Privacy Commissioner for Personal Data, HKSAR, and Ms. Carmen Tang, Senior Partner, Check and Associate LLP, will discuss the conflicting relationship and the ways to strike balance between data-driven marketing and sales practices. Please welcome our speakers of this panel, which will be moderated by Mr. Wilfred Ng, Senior Legal Counsel, Tencent. Please.
Morning. Thank you everyone for joining the first session of this conference, and to kick off today's meeting, hopefully with a very fruitful and insightful discussion regarding data-driven marketing activities. Today I'm very honored to be joined by my esteemed colleagues on the panel who are all established experts in the field of data privacy and data protection. And I very much look forward to today's discussion because when I first got in touch with the topic, I feel this is very much echoing with the spirit of today's theme, being the corporate connector. As all of you know, as in-house advisors and lawyers, we're often at this intersection between our stakeholders' interests and the compliance demands of our enterprise, our companies. And this is very much a vindication, I believe, being data-driven marketing activities of how all these sometimes conflicting, sometimes facilitating set of interests interact with each other. Today's structure is briefly as follows. As some of you may know, we will have individual presentations from our established speakers on the panel. And then this will be followed by questions facilitated by myself and also by the participants in the conference. If you have any questions, feel free. If you're joining by Zoom or if you're here today attending, feel free to raise your hand and we'll address any questions on any topics that we have discussed. Without further delay, if I can invite Commissioner Chong first to give her presentation on the overall lowdown on the direct marketing regime in Hong Kong, and then we will follow up with subsequent presentations from an enterprise perspective and also from the general industry legal challenges within the marketing space, especially from a data-driven perspective. So may I please invite Commissioner Chong. Thank you.
President, distinguished guests, ladies and gentlemen, good morning. And thank you very much for having me here. Today, I'll be talking about balancing data-driven marketing and sales with data privacy. I believe that marketing and sales must be one of the most important areas on which the advice of in-house lawyers are sought. And in today's presentation, as a regulator, I will try to highlight the basic regulatory framework on direct marketing under the Personal Data Privacy Ordinance. I will then give you a few examples of the more common pitfalls that I believe you should avoid in your daily operation. Let us look at some figures first. From this graph, you will see that in the past 3 years, my office has received around 115 complaints every year relating to direct marketing. And for this year, up to the end of August, we have already received 63 complaints in the area of direct marketing. And I believe that by the end of this year, the figure will be more or less 150. So it is in line with the trend over the years. As some of you may recall, the Personal Data Privacy Ordinance was amended back in 2012 to introduce a brand new regime to regulate direct marketing. And this is actually one of the follow-up actions to the famous Octopus incident. I don't know whether the in-house counsel of Octopus is attending, but I'm just giving a factual account. The incident, as you may recall, was happened back in 2010. And 2 years later, the ordinance was amended. And in that incident, a major blunder, I would say, was made by the company in that customers' personal data was sold to another company for gain. Firstly, what constitutes direct marketing? It's very important to understand the basic concepts for this particular discussion. Direct marketing is defined under the ordinance to mean the offering or advertising of the availability of goods, facilities, or services, or B, the solicitation of donations or contributions for charitable, cultural, philanthropic, recreational, political, or other purposes through, remember this limb, direct marketing means. And direct marketing means is in turn defined to mean the sending of information or goods addressed to specific persons by name. This part is most important. It has to be addressed to specific persons by name. And the dispatch mode is by mail, fax, electronic mail, or other means of communication, or making telephone calls, again, to specific persons. So if you look at the definition of direct marketing means, it appears that there is a loophole in the regulatory regime, in that if the message is not addressed to specific persons by name, this would fall outside the purview of the regulation. Is that the case? I don't believe that this is a loophole. I do believe that the legislative intention at the time is not to regulate or not to cast the net too wide as to unnecessarily stifle legitimate commercial activities. And if you think further, if the message is not addressed to specific persons by name, it's just a general message, it may not involve any personal data at all. It may not involve the collection or use of personal data. And if no personal data is involved, the PDPO, the Personal Data Privacy Ordinance, will not apply. And palpably, I do believe that it is the rationale governing the, the way direct marketing means has been drafted and applied. Essentially, under the ordinance, the direct marketing regime is divided into two main areas. The first area relates to the use of personal data in direct marketing. And the second area relates to the provision of personal data by the data user. That is a company, can be a company, or can be a sole proprietorship, or can be an individual, to the third party for direct marketing. So let us look at the requirements for the first particular area, the use of personal data in direct marketing. Under the ordinance, there are certain steps a data user has to take before he can use the personal data for direct marketing. And we call them specified actions under the ordinance. The specified actions mainly comprise notifications, the provision of a list of prescribed information, and also the receipt of the necessary consent. And I will be covering this one by one because they are the key components of the essential requirements before you can use the personal data of your customer in direct marketing. The notification requirement essentially requires the data user to inform the data subject, that is the customer, that he intends to so use the personal data in direct marketing. And the data user or the company may not so use the data unless the data subject consents to it. So you have to inform your customer of that, about his or her right to opt out. And that is a list of information, which we call prescribed information, to be provided to the customer as well. the kinds of personal data to be used, the classes of marketing subjects. This is also important. It means the goods or services which you are going to promote through the direct marketing, and a channel through which the data subject may communicate his or her consent to the intended use. So you have to give the customer a channel, whether it is by email, by telephone, or by sending a reply through clicking a box on the internet. And the third requirement is that you have to receive consent from the customer before you can use the customer's personal data. And the consent in this particular context can be in writing or can be given orally. So there are several requirements you have to go through before you can use the customer's personal data in direct marketing. Let me turn to the second area of covered by the regulatory regime, which is the area of provision of personal data to third parties for direct marketing. It is very similar to the scenario of Octopus, the provision of customers' data to another company for that company to carry out direct marketing. The requirements are actually very similar. Notification requirement, provision of prescribed information, and also the receipt of consent. But in this case, notice the differences are that the notification has to be in writing, and the consent has to be in writing as well. So there are some key differences between the two regimes. And in this case, the prescribed information will also need to cover the fact that if the data is to be provided for gain, that information has to be provided to the customer as well. So you have to be frank and transparent in the first place, and you have to tell the customer what personal data you are going to use, the classes or marketing subjects involved, and also the channel through which he or she may indicate his consent. Rights of data subjects, that essentially means the rights of customers. The ordinance expressly covers the rights in the relevant provisions. And essentially it means that even if the customer has given his or her consent to the use of his or her personal data in direct marketing, he can withdraw the consent at any time. And therefore, the ordinance provides that the customer or the data subject can request the data user or the company to cease to use the data in direct marketing. And secondly, in the second area, the customer can request the data user to cease to provide his personal data to another person for use in direct marketing. And also, the customer can request the company to notify that third party to cease to use the data in direct marketing. And the ordinance even goes further and say that once the data user receives such requests from the customer, the data user must comply with the request without charging any fees. Let us now turn to the part on liabilities and offenses. It's important to note that I've just outlined all the key or the most important requirements under the regulatory regime. And it's important to note that any non-compliance or contravention of the requirements may constitute a criminal offense under the ordinance. For example, if the company in question uses the customer's personal data in direct marketing without obtaining the necessary consent, this would constitute a criminal offense under the ordinance. And I will be talking about some prosecution cases later on. And for this offense, it attracts a maximum fine of 500,000 and imprisonment term of 3 years. It is rather a high level when you compare this to the other offenses under the PDPO, because at the moment, for most other offenses, the maximum fine is only $10,000. And that is why we are reviewing the ordinance to, if possible, to align the penalty level. The same, you will see that the same penalty level actually applies to a data user who, when using the a data subject's personal data in direct marketing for the first time, fails to inform the data subject of his or her opt-out right. In addition, if the data user fails to comply with the request to cease to use the personal data in direct marketing, he would also have committed an offense under the ordinance. So essentially, if you fail to comply with the requirements under the ordinance, you may be liable to a criminal offense. And similar offenses actually apply in the context of the provision of personal data to the third party for use in direct marketing. In other words, if the company in question, we can also use the octopus example. Nowadays, we decide to sell the personal data of customers to another company for gain, but without obtaining the consent of the customers in question. It would be a criminal offense nowadays, and it attracts maximum fine up to $1 million, because the provision of data is for gain. And if the provision of data is for gain, the imprisonment term is also increased from 3 years to 5 years. And for the other offenses, they are very similar to those in the first area, in the area of using the data subject's personal data without consent in direct marketing. Statutory defense. I've been talking about liabilities, criminal offenses, so I think to complete the picture, I should also talk about statutory defense. Under the ordinance, it is provided that for all these criminal liabilities, the data user has a statutory defense. And the data user, if the data user is able to prove that he has taken all reasonable precautions and exercised all due diligence to avoid the commission of an offense, he would have a statutory defense. Of course, whether the statutory defense is available to the defendant depends on the facts of each particular case. But in order to invoke this defense, I would highly advise data users to put in place a proper system for the handling of data to demonstrate that he has exercised all reasonable precautions and exercised all due diligence to avoid the commission of any offense under the ordinance. It is advisable for companies to put in place a proper system in the first place. It's not until something has gone wrong, then you try very hard to find some evidence to prove that you have taken all these reasonable steps. I will now turn to the more common direct marketing pitfalls that we have noticed from our enforcement experience. The first one is about the form of consent. As I have mentioned in the earlier part of this presentation, when the company uses personal data in direct marketing, the company needs to obtain the consent from its customers, and the consent can be in writing or the consent can be given orally. However, the ordinance also provides that if the consent is given orally, the company has to confirm the consent within 14 days. And for the provision of personal data during other parties for direct marketing, the consent can only be in writing only. So only a consent is valid, not oral consent. And technically, I think as a lawyer, I think I would advise you as your client to secure written consent as far as possible in order to avoid any dispute with the customer and to avoid any understanding with the customer. because if you got the consent in a written form, you can keep a record of that consent, and also you can update it readily and more easily. The second common pitfall is in the area of the design of the consent form. Again, to remove any possible doubt about whether there's a consent or not, and about whether the consent was voluntarily given, we strongly recommend that the form be designed in a manner that separates customers' agreement to the terms and conditions of the provision of service from the customer's consent to the use of his or her personal data for direct marketing. In other words, we would advise companies not to bundle the consent together. If you bundle the consent together, the customer might be misled to just put a tick in the relevant box, but actually he wanted to opt out from the direct marketing option. So the design of the form should ensure that the customer are given clear and also genuine choice to decide whether he agrees to the use of his or her personal data for direct marketing. Let me now turn to some cases. From our enforcement experience, actually many prosecution cases, I would say, relate to the withdrawal of consent and relate to the use of personal data for direct marketing despite the withdrawal of consent. Over the years, we have prosecuted quite a number of cases in this particular area. And if I may use as an example, last year, in September last year, there was a ruling by the court convicting an estate agent. And in that case, the property purchaser made an opt-out request to an estate agent. I don't want to mention the name here. You can see it from the picture. He made a request to the estate agent, to the firm itself, but he subsequently received a direct marketing call from a staff member of the estate agent asking him if he wanted to sell his property. Of course, he was quite angry. He made a complaint to my office. And after making some initial inquiries, we referred the case to the police for consideration of prosecution because we considered that there was prima facie evidence of contravention in the case. And last year, the case was heard and the staff member was convicted. And the judge in the ruling actually expressly said that the PDPO, the Personal Data Privacy Ordinance, not only applies to companies, but it applies to individuals and staff members of companies as well. So you have to be careful. Even for employees of a company, they have to be careful not to contravene the ordinance. If they are calling any particular customer, I will strongly advise them to check the opt-out list first. Because in this particular case, the estate agent, the staff member failed to check the opt-out list, and that's why he continued to call the customer in question, and that is a criminal offense. And at the end of the day, he was held to be liable. If I may share another case with you, in this case, the telecommunications company pleaded guilty to violating the direct marketing provisions. And in this case, actually, it stemmed from a complaint lodged with my office. The complainant has subscribed broadband service with a telecommunications company, and again, he opted out the use of his personal data in direct marketing. Notwithstanding that, the complainant still received free direct marketing calls promoting a new service plan. I do believe that many of us have this kind of experience. Over the past few days, I have so many calls from my telecommunications company agent asking me to renew my plan. And the complainant, of course, was quite angry. He made a complaint to our office, and we have made some inquiries into the matter. And the case was again referred to the police for further investigation and prosecution. In 2020, about 2 years ago, the telecommunications company was charged, and the company pleaded guilty to 6 charges and was fined $12,000. I would say the lessons from this case are that never ignore customers' opt-out requests. And for companies, it is highly advisable for them to develop and implement policies as well as provide proper training to employees in order to ensure that the requirements of the ordinance are complied with. I will also advise that companies should always keep an opt-out list and maintain and update the opt-out list whenever they receive any opt-out request. Because it's really no point if you are not updating your opt-out list. If the opt-out list is outdated, you are putting your staff members in trouble. Let me wrap up this part of the presentation by another case. This case illustrates that the failure to adequately inform the data subject can amount to a criminal offense. This relates to the notification requirement. And in this case, the complainant, the lady in question, received an SMS on her mobile phone addressing her by her surname from an insurance agent for promoting a new saving plan. And the lady said that she did not know the agent. The insurance agent was not her agent. And he questioned how he obtained her surname and telephone number. The agent failed to provide a reasonable reply or a satisfactory reply. And neither did the agent notify the lady of her opt-out right. So apparently there are 2 contraventions here. Firstly, failure to comply with the notification requirement, failure to provide the prescribed information, and also failure to inform the complainant, the lady, of her opt-out right. At the end of the day, the agent was charged and he was convicted as a result. So be careful. Any non-compliance or contravention of the requirements under the ordinance may constitute criminal offense. And so you better be careful whenever the company seeks advice from the division, from in-house counsel, from your legal division. You have to give proper advice based on the law. So I've come to the end of my presentation. For those of you who are interested, you are most welcome to take a look at our website. We have issued a guidance on direct marketing, which provides, I would say, very helpful advice on quite a lot of issues in this area. So if you're interested, please go to our website and take a look at the guidance. For today's PowerPoint, I will also upload it at our webpage. So there's no need for you to make any photos. Thank you.
Thank you very much, Commissioner Chung, for a very detailed run-through of Hong Kong's PDPO direct marketing regime, which I believe also sets a very good foundation for the 2 subsequent presentations for today. If I can now turn to Aaron, if you can hear us clearly, thank you again for joining us remotely today. And I'll pass the time to you to give us perhaps your thoughts and some of your practical tips, if I can cue you in that manner, particularly from a data user's perspective with regard to data-driven activities, and particularly interested in your views, in the lens of an in-house advisor as well as your internal stakeholders of marketing teams. So thank you, Aaron.
Can I do a sound check, Wilfred? Am I clear? Can you hear me, Wilfred?
Can you hear us, Aaron?
I can. Can you hear me? My microphone is working.
Not sure if you're muted.
No, I'm not.
Oh, okay, we can hear it perfectly. Thank you.
Okay, great. Yeah, great. So yeah, apologies first off for not being there in person today. One of my kids brought back a stomach virus over the weekend, and it's been knocking down members of my family one by one. And today is my turn. So I will be making this presentation, but I'll be signing off right after. So apologies to Wilfred, Ada, Carmen, and the Law Society as well. But thank you for your time. I'll share my deck now. Right, so can you see that, Wilfred?
Yep, thank you.
Great, yeah, fantastic, thank you. My name is Aaron Bleasdale, and I'm the Regional Data Privacy Lead Lawyer for HSBC in Asia. The views I express here are entirely my own, I have to say that. I won't try to compete with Ada or Carmen on explaining the law. I think that's really well covered. But I will try to share some insights on marketing and data privacy compliance, as Wilfred mentioned, from the data user's perspective. I know today's a long day, probably pretty long for me too, so I will try to keep things light. Banks have been in the business of protecting customer data for hundreds of years, but data privacy is a bit of a different beast. Data subjects have an awful lot of rights of varying kinds in respect of their data, and data users have a new range of responsibilities. And as our society collects and uses more and more data in more complex ways, fulfilling these responsibilities can actually be a little bit more of a challenge. Marketing and analytics teams may get excited about hoovering up personal data whenever they can, but anyone in the data privacy space knows we shouldn't be doing this indiscriminately. And perhaps the duties and risks that come with this data and having this data outweigh the benefits of having it. So data governance is a really slippery animal. It's a very tough challenge sometimes, and perhaps some of my presentation will resonate with your own experiences, particularly if you're in-house, but maybe if you're advising companies on direct marketing. And next slide. Here we go. When the PDPO was amended in 2012 to include direct marketing, companies in Hong Kong scrambled to understand how it would impact their existing marketing activities, of course. And they, of course, were very interested in how they could qualify for the grandfathering provisions. I was around back then, and this was a hot topic for sure. I think the urgency for these companies was the adverse public reaction. It was partly due to the adverse public reaction due to recent marketing-related violations of the PDPO by some well-known brands here in Hong Kong, but also the breach of the new provisions in Section 35. You could be fined directly without first needing an enforcement notice and breaching that enforcement notice from the Privacy Commissioner. So this got people's attention, and the quantum of the fine for direct marketing back then was higher than for breaching an enforcement notice. Following the amendments in 2012, which I think came into force in 2013, direct marketing complaints increased. It's fair to say that data subjects had been empowered, and data users had been put on notice that they needed to clean up their acts in respect of their marketing activities. Now, just on this slide, I want to highlight that the guidance note in the top right, the new guidance on direct marketing, is a really fantastic resource for anyone who wants to understand a bit more about this space, because it provides the law, but also some really excellent examples and use cases. So really worth a read if you haven't read it already, or if you need to learn about direct marketing requirements. And a highlight on the right of this slide, my definition here of direct marketing, or it should be direct marketing means, I've underlined addressed to specific persons by name. Ada, I must say, great persons think alike, because you did the same, because it's relevant to a point made later in my presentation. So just leave a mental bookmark there about this, and we'll come back to it. Now, what I'd like to do is talk through 4 thematic challenges that pop up for data users. And data users now all should have procedures in place, as Ada's recommended, to comply with Section 35. But of course, complexities can emerge in practice. Businesses, they need to educate and constantly remind their marketing, sales staff, analytics teams frontline staff and maybe especially their senior management about basic data privacy requirements, or apologies, direct marketing requirements. And even if they don't quite understand them, they have to be a little bit maybe afraid of them. It sounds bad, but for example, marketing teams should recognize the existence of your opt-out list or your marketable, non-marketable list, whatever you call it, and understand that the consequences for not respecting it could be worse than season 8 of Game of Thrones. And if your business understands that customers can opt out at any time, then maybe that will make them just a little bit more retrospective or introspective before they start spraying your customers or their customers with marketing materials. But as this slide shows, there's always room, even with education, for operational mistakes and errors. Frontline staff, new joiners, fresh graduates, bless their hearts, can always gum things up. And so it's really important in an organization to build hardwired checks and stop gates that prevent breaches where they occur and prevents errors where they're most likely to happen, perhaps even making them impossible if you can build that kind of control into your processes. This is much more effective than relying on a procedure document sitting in an unloved shared directory somewhere. To err is human, as they say, so do what you can to make it hard or impossible to err. And think even if your staff, bless their hearts, get everything right, there's every possibility that one of your vendors, for example, a printing vendor could make an error and send thousands or whatever number of direct marketing solicitations to non-marketable customers. So vendor management is another important piece of the puzzle. And the last tip here in terms of operational errors and mistakes is consider splitting marketing initiatives and outreach into sections or tranches. If you do have an error that occurs, you can catch it early and not across your entire customer base. And what's also very important is that you'll know who's been inconvenienced, because it's an identifiable and hopefully small set of people that have been the beneficiaries of an operational error. Now, moving to the second challenge, I think if you're in-house, you can all relate to this. Enthusiastic marketing teams. It's really important to keep your marketing teams on a tight leash, particularly in Q2 of the past couple of years, when COVID restrictions have loosened and businesses started scrambling to catch up on their annual sales targets. You may have noticed this trend yourself. Now, servicing messages are not marketing messages. So I'm drawing that distinction, and they're not subject to the requirements of Section 35. You can send servicing messages to existing customers all you want, regardless of whether they're opted out of receiving marketing. So sometimes marketing teams, bless their hearts, might be tempted to test the boundary between these two kinds of messages. So you need to police this line very closely. Or they may try to insert just a little bit of marketing, no one will notice, right, into an otherwise entirely servicing message. I think the message here from me is to make sure that you have someone that looks at these customer messages before they go out, someone that knows the difference between a servicing and a marketing message. And even if the PCPD is satisfied that a message is a servicing message, your customers may not be as interested in these fine distinctions. So extra incentive to exercise some care. And broadly speaking, with your marketing teams, it's very important that they have complaint risk, privacy or direct marketing complaint risk factored into their calculus when designing these campaigns. Generally, businesses need to keep a holistic view of the messaging customers receive through varying channels, when and how frequently, or they can risk overwhelming or annoying their customers, particularly if you have a very large business with a lot of customer touch points. A little known fact, you can annoy customers even while complying with Section 35. Now, moving to the third of the challenges, confusing opt-out journeys. This really is very difficult to manage in a large organizations. If you have, for example, different opt-outs for marketing for different business lines or product lines, just customers will not distinguish between them. They'll see the brand name, that's it. So for example, if a customer does not want to receive any shoes marketing and opts out of receiving shoes marketing, it's a bit of a rough example, but they are still marketable for jackets marketing, and you send them legitimate jackets direct marketing, what's the probability or the chance that they would complain? They might, because they would not appreciate or even remember potentially that they are still marketable for the jackets. And another question is, do you, if you're a company, have systems in place to adequately record and track these different preferences? And that's an important thing to have in place. Try to have clear, consistent language and tick box mechanics for your direct marketing opt-outs to avoid confusing customers. Avoid double negatives and other misleading tick box approaches. I mean, this can happen purely accidentally and not with any malicious intent. So you do need to scrutinize how these opt-outs are being designed and conveyed to your customers. The object is clarity and not ultimately to trick them into receiving marketing. And another point that is an interesting one that many will not have thought of, or maybe you have, it might seem like a good idea to just put a direct marketing opt-out tick box into every document or customer touch point you have, but it really isn't. Continuously offering your customers the opportunity, the chance to opt out does cause confusion, mistakes, and may even be coercive. You give someone 100 chances and they miss the last one, all of a sudden they're magically marketable. No, so you do need that overview of the customer experience, which again is very difficult sometimes to craft clear customer consent journeys. And the last point I'll make on confusing opt-outs is that it can be really helpful to have an online preference page somewhere that allows customers to manage all these preferences all in one place. And you can use this as your golden source for marketability status. So it's a very useful resource, and it really does add to a customer's ability to exercise choice and control over their marketing preferences. You can also include channel preferences. For example, I don't want to receive any phone calls, please. Ada, I guess we have that in common, but you might be willing to receive postal marketing. I'll open a letter and have a look at that. So maybe you can offer that optionality to customers so they can receive what they want without just blocking all kinds of marketing. Ideally, every data user should have a clear preference channel, easily found and often shared with customers. Now, the last challenge I want to touch on, if I can find my cursor, apologies, here we go, is privacy notice fatigue. It is a real thing. How much time do we realistically have to read all the privacy notices we're asked to read or we're confronted with? And can you expect your customers to read all these privacy notices? And if they don't, how can you say your notifications were effective? It really is a problem for everyone. Now, a few years back, after pretty extensive customer usage testing, legal advice, and even regulatory consultation, it really was a pretty big job. HSBC rolled out a shorter privacy notice for its retail customers. It retains the required notifications while greatly increasing its clarity and its likelihood of being read. We've received really very broadly positive feedback about this shorter notice. No complaints, which is telling, and we know for a fact that more people are actually reading it, which we think is it's a big win from the privacy side. So each data user, of course, will need to manage this balancing act in their own way, but clarity and maybe brevity has its value. And resolving these questions and challenges, the ones I've just described, can also often involve subjective judgment calls. Now, no one likes the ambiguity of a subjective judgment call, but we do have an advantage in this respect in that we all have personal data, and we should have an innate sense of whether a data processing activity, a direct marketing initiative, or any processing activity at all might annoy or be viewed as a little off base by a customer. So and often we are the customers as well. So we should have this sense. So try to act ethically when you're in these gray areas, act accountably, and really ask yourself, how would I feel if I were treated this way, or if this were my personal data? Now, I think what I'd like to do now is pivot a little bit to what marketing practices, how they've evolved over the past 10 years. The last decade, and I think this cartoon is funny, special thanks to Tom for this one. The last decade has seen a lot of change in marketing practices. It's really a lot more data-driven now, right down to the individual customer level. It turns out that marketing, targeting your marketing at people who are more likely to want your products actually works if you're trying to sell your products. And knowing your prospects allows you to tailor those messages to be maximally impactful. Knowing your customers can help you to tailor your products and services to better serve their needs. It can also help you to cross-sell or upsell to them. So you can see how powerful this more targeted marketing actually is, but of course, to do it, you need to collect more data. Now, fortunately, due to the time most of us are spending online, we are all now leaving massive digital footprints behind us everywhere we go, pretty much. So any device connected to the internet could be helping create this footprint for you or of you. And profiling, although it's not itself direct marketing, the PCP guidance says that collecting personal data for profiling purposes that are not related to the services that you're providing, so they're for a different profiling purpose, should only be voluntary, which is a really good, important note to make. But it's interesting now that sometimes it's a bit of a moot point because profiling increasingly is the service or a huge part of the service. So it's a bit inseparable now. Can you imagine Netflix, for example, without program recommendations? I would be watching a lot less Peppa Pig. And this is another thing I can blame my children for. I'm not holding any grudges. Now, before we skip to the next slide and explore marketing just a bit deeper, it's worth stepping back and asking, do people appreciate targeted marketing? This is an interesting question, and marketers will tell you, yes, of course, everyone wants targeted marketing. It makes it more relevant to people. Maybe. 15-year-olds may not want to see ads about arthritis cream. That's pretty hard to deny. But what's interesting is that older people may be even more annoyed to receive ads about arthritis cream. I find personally personalized ads to be a little bit invasive, but I also get annoyed when a personalized ad that I receive has made some incorrect inference about me because it's not personalized enough. So obviously some complex feelings here, and perhaps the takeaway is to keep your targeted marketing away from being a little bit too creepy. So Ada, I guess one recommendation for the upcoming amendments to the PDPO is to include a creepiness test. I will leave that out there for you to consider at your discretion. There are also many ways to make profiling and targeted marketing less creepy. For example, you can categorize your customers into buckets. This avoids being too personalized in your outreach, but of course, do also be careful how you label those buckets, and you might not want to tell your customer that you put them in a bucket. But that is a good way of reducing the creepiness of your outreach by making it just a little bit less personalized. Now, if it's true that processing personal data involves extra responsibilities and risks, it would be much easier, surely, if someone else did this for you. Well, yeah, this is the business model of some of the most profitable companies on earth. I think you can see them there in the window looking in this comic. These companies collect the data, a lot of it from their own online platforms. They do the profiling of their users, and they either sell you their insights or they use their platforms to do the marketing for you. And it makes a lot of sense because you're not the data user in respect of this profiling. You're not doing the marketing. Essentially, you're just buying ad space in someone else's online environment. And if it becomes undesirable or unfashionable, you can just stop using the service. Now, you may also have noticed that people are spending more and more time in these online environments, and this is the final point I'd like to make in my presentation, maybe a bit of a futuristic look. Not only can a ton of personal data be collected in these online environments, data that enables profile building, but these environments are also really great environments to market products and services to people. People's experiences in these environments can be totally controlled and shaped to deliver marketing in innovative ways. And harking back to the bookmark and to Ada's comments, not necessarily addressed to people by name. You don't need someone's name when you can just put billboards and product places all throughout your own customizable digital environment or experience. So I think a key point here is that direct marketing rules, the ones that we've been discussing, may not apply to many of the marketing activities in these environments. And I think maybe that was the point that Ada was making, that it's not a loophole. Maybe that's intentional. But I would remind that even if Section 35 doesn't apply, the privacy principles will still apply because it's personal data. Now, on my last slide, perhaps you've heard of the Metaverse. Well, essentially, it is the next level of digital immersion. It's the digitization of human activity, where physical and digital lives converge. Now, I'm hearing a little bit of an echo on the line, so if maybe we can look at that. I don't know if other people are hearing that as well. But in the metaverse, activities like work, play, socializing, shopping, and all kinds of commerce, they happen in parallel and in connection with the physical world. And bit by bit, whatever you think about the metaverse, we may all be forced into it in some way or another. It's not hard to imagine a future where people or their avatars routinely travel through the metaverse, visiting different worlds, not unlike how we visit websites today. And what takes place in these different worlds may be as important or almost as important as what takes place in the real world, or the physical world, I'll say. And of course, these popular worlds that people visit will be immensely valuable because of the economic activity taking place in them, the services that can be sold, the ad space that can be sold, the rents collected, and also, of course, the data collected. So all this might seem a bit alien to you now, but it probably won't seem so alien to your kids. Where do you think they've been for the past 2 years? They've been thrust online due, I suppose, to our pandemic response. And companies are already meeting them there, targeting them and profiling them there. So it might seem like a little bit of a remote idea to you, but trust me, your kids are all over it. Now, the metaverse itself is in its nascent stages, being conceptualized and built, and may even seem abstract or silly to you. But recall that even though many early internet companies went bust in the dot-com bubble, the thesis that was driving the bubble was not wrong. Pets.com is no longer around, but the internet did change our lives. So you may not want to spend time with Zuck in the metaverse, but chances are you won't have to, because we may all be spending more time there in the years to come. And I close my presentation asking the question, how are we going to protect people's privacy rights in the metaverse? Well, fortunately, this isn't my job to do or decide, but I think the ethical accountability framework issued by the PCPD in 2018 is a good start. It encourages data users to process and handle personal data in a manner that is, and I'm sure you've heard this before, respectful, beneficial, and fair, and hopefully not too creepy as well. So with that, thank you for your time, and it's been a great pleasure to speak to you. Thank you.
Thank you very much, Aaron.
Thank you,
for
Wilfred.
your sharing, and wishing you a very speedy recovery. And sorry that you won't be able to join our Q&A.
Yeah, I'll drop now. Thank you. Yeah, and I'll stop sharing.
Thank you, Aaron. With that in mind, I think our next speaker, Carmen, will follow on very well with this theme about practical applications, because I'm really interested in hearing her sharing and her thoughts, not just on the challenges about meeting the law or in terms of fulfilling legal requirements and obligations, but also essentially the balance between our legal requirements and also creating a culture from the perspective of user and perhaps instilling even an accountability brand image from the companies and an enterprise perspective. So I'll pass the time to Carmen for your sharing. Thank you.
Thank you, Winfred. Good morning, everyone. This year marks the 9th anniversary of the Hong Kong data marketing regime in Hong Kong. So let's take a look at how companies have adapted to the development of the regime since then. There are several areas that I would like to talk about today. First, the cases. Secondly, the commercial world, that is what the companies have been doing. What's in their mind? Do the companies prioritize privacy for consumers? Apart from regulatory compliance, what do data protection mean to companies in Hong Kong? And last but not the least, to look at the challenges in a culture against targeting ads and retargeting ads. So first, let's have a recap on the data marketing regime in Hong Kong. There are specific acts that data users required to do before they can use the personal data on direct marketing purpose. First, as Commissioner has mentioned, there is a list of prescribed information that data users have to notify the data subjects beforehand. Second, obtaining prior consent is a must. And third, response channels should be provided to data subjects for opt-in or opt-out. So let's take a look at the number of convictions here. For the first and second convictions, you can see that they happened in 2015. For the first case, the defendant was fined 30,000 Hong Kong dollars, and the second one is 5,000 Hong Kong dollars. So from this chart, you can see that over the past 9 years, there were on average 3 to 4 convictions per year. And most of the defendants plead guilty, and the reasons for breach of the ordinance is either the staff concerned may not be aware of the existence of an updated opt-out list, or the list itself was not updated. And there are a few cases involving the insurance agents and estate agents who have obtained personal data from work or other elsewhere, and then used that for direct marketing purpose for their own good. So in most cases, the defendants were fined in a range from 2,000 Hong Kong dollars to 10,000 Hong Kong dollars per charge. And the landmark case as of today, it's involved a telecom provider who sent 23 direct marketing messages and emails to data subjects in 4 months' time. And the defendant was fined in a total sum of 84,000 Hong Kong dollars. So what are the implications here from the figures? So comparing to the fines imposed by FTC in USA, for example, like the Facebook case or in the Mobi case, the deterrence effect of prosecutions under the regime in Hong Kong may seem debatable. But let's pause here. So in the long run, should laws and governments be the driving force for data protection in Hong Kong? I remember in the year of 2018, when the GDPR's commencement day was approaching, companies also start calling their professionals for help. Some of them may not have paid special attention to privacy issues before. That's why when the new regulations came out, they felt frustrated and annoyed. They sought legal advice because of the uncertainty on enforcement. And I believe everyone knows that for the GDPR, the fines goes up to 10 million euro or 2% of the global overall turnover, which companies cannot ignore. But the thing is that simply staying compliant cannot be the end goal. So what is sustainable in the long run? A win-win situation. But what is a win-win situation? That is, data users and data subjects, they are gaining value and benefits from data exchange and sharing. So let's take a look at what companies do in Hong Kong. What does personal data protection mean to them? The easiest ways to learn about a company's core values and areas of interest. It's from their annual report and also recently the ESG reports. And we discovered that more and more companies have highlighted the measures on data protection and security in the ESG reports, which is a very good start because they have become aware that people nowadays do highly value their data privacy. And there are several things that companies would highlight in their reports. For example, one, the existence of a privacy policy. Second, they have conducted internal trainings and workshops for staff to enhance their awareness on data protection. And as far as information security is concerned, they have executed audits and reviews. So from theory to practice, let's look at some of the daily examples. So when we all go to a website to search something, I think you guys will not feel surprised to see tons of roadblocks that coming all over the place on a website that blocking your view. The roadblocks that I'm referring to are actually the banners, the flashy pop-ups. They are the cookie banners that for the people to opt in and opt out. For these examples, you can see that the designers have actually put some thoughts on the user's concern. That's why the banners are actually set at the bottom instead of flying here and there over the website blocking you. But let's see. So before the users decide to opt in or opt out, they would like to know what kind of data that the companies would collect and they would use and how they would deal with the data. So at this time, the users would be directed to pages and pages of policies. And sometimes the policies are so long that even longer than the submissions that we make in court nowadays. So imagine that you have to browse 10 to 20 websites, not just on your mobile phone, and also on your laptop or desktop and other digital devices. So maybe a raise of hand, how many of you would actually read word by word the whole policy before you click the accept and reject button? So in the privacy community, we got this term to describe the interfaces that nudge users' behavior towards choices that he or she may not pick if the options are presented to them differently. These are called the dark patterns. For example, like confusing language, complex language, interfaces that encourage people to pick one option over the other, interfering pop-ups. So there is one common thing among these features. That is, there is no real option for configuration for users. So here comes the fallacy. Many companies believe that with this kind of mechanism, this can shorten the user's time in thinking, and then they will just provide consent so as to stop going through the hassle as soon as possible. But the reality is that because these kind of pop-ups or interfering interfaces, they are quite intrusive or scary, so users tend to be more careful. And if they do not have time and they do not want to take a look at lengthy policies, they will simply close a window and just jump to another site. So for companies who decide to let people have a choice on data processing, they should let them have the ability to exercise that choice. So what does mean by the transparent and meaningful choices? So you can see this example here. So on the left-hand side, there is a box. So it's a small paragraph, and there's assistants that guide the users to manage their own consent preferences and also make informed choices. The data are categorized into 4 categories. That is, first, strictly necessary, also functional, analytical, and also targeting. So under each type of data, there is a cross sign. So when you click that cross sign, you can see a small paragraph that telling people the purpose of collection and also what would happen if you do not provide the data. And after the users have set their preferences, they will need to scroll to the bottom and click the Confirm My Choices. So this is another example that you can see it is not necessary to have those flashy pop-ups flying here and there for the seeking consent. And I'm sure those who have been using this brand's phone are familiar with the features that they have settings for users who can customize their privacy preference for different applications in that phone. So we have been talking about what the companies are doing and what they think. So let's take a look at the consumer's perspective. So consumers, of course, they are concerned about their data privacy. When they cannot see, when they are not well informed, they are kept in the dark, and they are afraid that their data may be used behind their back on purposes that they don't want. But on the other hand, they know well about the benefits of sharing data with businesses. For example, like getting free product sample, discount on future purchase, gaining personalized experience, and also learning new products that's suitable for their needs. So when their concerns are addressed, actually this will create positive impact for companies and also consumers. So what companies should do is to treat the customers in the same way as in the real world. So imagine that when someone walks into your shop, you will not force them to buy their product as soon as possible. You will interact with them, you will answer their inquiries, and then give time to think and let them make the decision at the end. So lastly, let's take a look at the challenges on targeting and retargeting ads. So these are the products of behavioral advertising. The digital platforms and websites, they gather information from digital footprints and also online activity. They collect the data, analyze it, and then deduce the type of ads to send to the users. So you can see these interfaces and also ads that have actually been appearing on my own account. So for lawyers, we do on and off need to search technical terms and do translations online. And all of a sudden, the platform thinks that it's time for me to brush up my English skill. So they kept on sending me these English lessons ads. So actually, you see, it's the same company. And this is another example. You may recall from the previous slides that I've shown on the cookies banner. And for the purpose of preparing this presentation, I have landed on this brand's website for a few times. And now the platform thinks that I must be a fan of this brand's product. So whenever I search something at work or browse internet during my leisure time, they will direct me to see these ads of this product. So the issue here is that the original purpose for this existence of targeting and retargeting ads actually vanished and is long gone. Because for personalized marketing, the companies wish to ensure the brands to reach the persons that are genuinely interested in what they have offered. But apparently this is not the case here. So what companies can do to fix the situation? So we can see the example on the left. When you go to this website and you scroll down to the very bottom, there is a small box that asks you in what capacity you come to visit the site today. For example, if you are a customer, you come to the site to manage your account, or you are new, you want to learn about the products there, or learn about the discounts or deals, or sometimes maybe job candidates that they want to find a post with the company. So with this information, the company will have a better idea of the purpose of each user's visit, and so they will be able to generate more personalized ad to the suitable ones. And on the right-hand side, you can see that this is an ad that allows the interested party, the genuine interested parties, if they want to know more about the site or the brands or the products, they can sign up for updates. So in exchange, they will have a discount of 15%. So you can see the ad is straightforward, clear, no hidden information, and that's what the customers want. So the key takeaway is that to have a responsible data practice is very crucial because this not only just build trust, but also provide opportunities for business growth. So thank you very much. This is the end of my presentation. And if there is any question, you can contact me through the QR code as well. Thank you very much.
Thank you very much, Carmen. We've now entered into the Q&A session, so do remember questions are open to the floor, and I will try to open up the Zoom questions as well as to exercise my own prerogative as the moderator to facilitate some of the discussions. So let me just open the questions. Before we turn to the Zoom questions and also any questions from the floor, allow me to, as I said, excuse me, exercise my discretion as a moderator and to benefit myself because I can already pick out a very recurring theme from very fruitful presentations from all speakers, specifically from Commissioner Chong's emphasis about the direct marketing regime on the need to address someone by name. And to follow that with what Carmen has just said in the digital and online environment, and also what Aaron has repeatedly said in his slides as well, that sometimes we do ignore the fact that online activities, and particularly when our data, which doesn't seem to be processed in a conventional way, be it a paper form, be it a collection in a tangible manner, then sometimes as companies and data users, we seem to have placed a lower emphasis from a compliance perspective, and somehow seem to get away from that kind of compliance hurdle. And I think in that spirit, I'm interested to, again, sorry, because we're all lawyers here, to go back to a little bit about the law, perhaps to ask Commissioner Chong to share some of her thoughts about perhaps what's the regulatory perspective regarding a marketing activity in situation A, it's a B2C situation, and versus situation B, where it's a business-to-business or enterprise-to-enterprise marketing communication.
Thank you. Thank you, Wilfred, for the question. Talking about B2C, business to customer, I think that is the normal scenario, and the usual rules would apply. But talking about B2B, business to business, I would say the scenario is more complicated because, as you can remember from my presentation and the presentation of other panelists, one of the essential criteria under the law is that the message or the information has to be addressed to specific persons by name. So insofar as the message or the advertising is addressed to a company, not to an individual, I would say it falls outside the purview of the PDPO. However, insofar as the business is a sole proprietorship or a partnership, and the message is addressed to the sole proprietorship by his name or the partner by his name, then it will be caught again by the provisions of the PDPO. Therefore, it really depends on the situations in question. I would like to also point out that it's rather common for salespeople to approach, for example, an employee of a company. So what happens to that? I would say insofar as the employee's personal data was collected in his official capacity, the call was only directed as, say, the marketing manager or the procurement manager of a company, and the marketing efforts relates to a product for use in the office. For example, an office photocopier. and the marketing efforts target the company in question rather than the procurement manager himself, in that case, it will also fall outside the purview of the PTPO. Because under the PTPO, we are talking about information or messages addressed to specific persons by name. So if the marketing efforts target the company in question, and the employee was only a representative of the company, that will fall outside the purview of the ordinance.
Thank you, Commissioner Chung. I think that raises a very good point, if I can extend that a little bit further as well. Perhaps not just in a B2B specifically addressed to someone in an official capacity situation, but also what Carmen has talked about, for example, dark pattern, whereas there's sort of an explicit absence of conventionally identifiable things like by name. It might not address me as Mr. Ng, but it somehow knows my behavioral patterns. In those situations, maybe Carmen, in your observations, what, again, also in the spirit of your presentation, what are the things that enterprises can perhaps do better, knowing that obviously there is a personal data element there, there's a processing there, but somehow enterprise and maybe your clients need to be aware that this doesn't get them away from direct marketing regime and also the PDPO framework.
Thank you, Winfred. So often people have the feeling that there may be a conflict between the compliance with the laws and also doing direct marketing. And people tend to criticize the laws. They are not catching up with the technology change, or if they up to speed, endless debate will result. So maybe let's step back and think about the original purpose for having data privacy laws. The laws aim at allowing the data subjects to regain the control over how the personal data is to be used by whom and the reasons for that. So for fines and penalties, they actually serve as a warning and alert to companies to press them to review and evaluate what they have been doing in the past on data processing. Of course, every company wants to make money, but having accountable practice doesn't mean that this will contradict the goal. In fact, in the opposite, this will create competitive advantage, allow them to outperform their rivals. So when the people knows what the companies are doing, they actually feel safer. They are more willing to engage, and this will build trust. And for example, the consent preference that I showed earlier in my presentation, you can see the whole consent seeking process is not just a one-way thing. From the interface, the language is used, you can see whether a company actually cares about the data subjects, whether they respect their ownership rights over their personal data. So when the data subjects feel that, they will be more willing to shop at your site instead of the others.
Thank you, Carmen. I think before I turn to some of the Zoom questions, may I just check if there's any questions from the floor? Yes, the gentleman in the second row. Yes, please do.
Hello, Ada, you are not only the privacy commissioner, but you were formerly the company registrar. So I want to ask a very basic question. A lot of people come to my organization, which is incorporated under Hong Kong, to ask for my membership list. And anybody under the company's ordinance can come and get that data. So I normally fend them off by exactly using marketing rules. I say, I can give you the information, but you can't use it. So then they fend off themselves, they just stop. But I think that there is a little bit crossover from the company's ordinance and the PDPO, that little gap, which public seems to be able to go to a company to get the membership list when they are not a member. So is this something that you could actually consider for reform?
I think I'm no longer the registrar of companies. I think this question should be directed to the incumbent registrar of companies. I think it is a good question, but if we are looking at it from the angle of companies law, the basic concept of opening up the register of membership to the public is to enhance the transparency or ensure the transparency of anyone who operates the company. Because a lot of stakeholders, such as customers, creditors, they know to need the members of the company. And that is why under the company's law, there is a regime for members of the public to go and take a look at the register of companies. If I look at it from the angle of privacy law, actually it's also covered by some basic data protection principles. I would say insofar as a register is kept, that is a purpose for the collection of the data. And anyone who collects that data from the company's register have to observe or will be restricted by the limitation of use of that register. And therefore, he cannot obtain the data from the members register and use it for direct marketing purposes, because it is only meant, I think there's a section in the company's ordinance, section 45, saying that you can only obtain information from the register for a specified number of purposes. For example, for the purposes of dealing with the company, for the purposes of knowing who are the directors or members of the company. So you are still subject to that limitation of use principle under the privacy law. So there's essentially no conflict between the two areas of law here. I hope I have answered your question. But talking about law reform, I'm no longer the registrar now, so I better leave that question to the incumbent registrar.
Thank you for your questions, and thank you, Commissioner Chong. I'm aware of time, so again, if I may exercise my discretion as moderator, I'll try to group the Zoom questions into one, perhaps preliminary single response by me with the blessing of Commissioner Chong. I know that there are already a few direct marketing regime specific questions, which I think I know that they can be found in a direct marketing guidance, namely how to opt out, and particularly a question on whether push notifications can be bundled with service notifications, and I think that would be an issue of the bundling of consent. And also, last question regarding whether we can just state a general message that this is not a direct marketing message, which I believe wouldn't already constitute, wouldn't avoid you from being regulated by the direct marketing regime. And again, to Aaron's earlier point, I think we can all find a lot of insightful resource in direct marketing guidance by the Commissioner's office. With that in mind, I think this is about time, and thank you very much everyone for your attendance online and physically here in this room, and we hope you all enjoy the rest of the conference. Thank you.
Thank you, Aaron, Ada, Carmen, and Wilfred. Could I ask you to stay on the stage as the Law Society would like to present you a souvenir? May we invite Mr. Siam Chen, President of the Law Society, to proceed to the stage and present the souvenirs to our panelists. Mr. Wilfred. Take a group photo. Thank you, President, and thank you again for our panelists. We'll now take a short break before we move on. Please return at 11:10 a.m. for our next panel discussions. See you after the break. Welcome back to our second panel discussion of today. Many business issues intersect the legal and HR functions of a company. In this section, we have invited Ms. Fiona Lowfrey, partners Simmons & Simmons, and Ms. Michelle Tennant, Director and Head of Employment Legal, Asia Pacific, Deutsche Bank AG, Hong Kong branch, to share their experience on tackling common legal employment problems and tips for in-house lawyers on establishing an effective working relationships with the HR team. Joining them is the moderator of this panel discussion, Ms. Joyce Cheng, Senior Corporate Lawyer, Australia and New Zealand Banking Group Limited, and member of the In-House Lawyers Committee. I shall now hand over to Joyce. Joyce, please.
Thank you. Good morning, ladies and gentlemen. Good morning, ladies and gentlemen. Welcome back from the nice little break. I hope you've got a chance to catch up with friends, to catch up with your emails, or perhaps a cup of coffee. And welcome back for those participating online. It flows very naturally from the first session. We talked about privacy in direct marketing and also in sales. But actually, in the HR world, personal data is also very important. But of course, this is not just about personal data. Us as in-house lawyers is the corporate connector. The relationship between legal and HR is crucial, is critical nowadays in the whole cycle, say, from the development for the company about like tenant recruitment, talent retention, incident handling, policy making, process management, etc., etc. So the relationship between HR and legal and whether there is any effective alignment is become more and more important. And sometimes there are like funny moments between HR and legal, and this is what we're going to talk about more in this session. And I'm very honored to be the moderator of this session. This session is going to be a free-flow, conversational panel discussion amongst the speakers. And we hope there will be about like 5 to 10 minutes towards the end for the question and answer session. So let me introduce our esteemed speakers. Ms. Fiona Lowfrey, partner at Simmons & Simmons. I think no much introduction needed. She's the leading employment law lawyer in Hong Kong. And also Ms. Michelle Tennant, Head of Employment Legal Asia Pacific of Deutsche Bank. We are very happy to have a representative from the private practice and also a representative from the in-house employment legal department to talk to us on this topic from the different perspectives. So Fiona and Michelle, as I mentioned in my introduction, I think the strategic collaboration between legal and HR is very important to minimize or reduce the risk of employee claims and investigation, but it's also very important for the corporate to build up their positive reputation and actually culture for the company as an employer. But then it's easy to say, when it comes into practice, there are like some frustrating moments. For example, like during COVID, the employment-related legal requirements keep changing constantly. For example, from the HR perspective, everything is so sensitive and confidential. For example, like whistleblowers, complaints, investigations, that kind of matters, handling of that kind of matters could be quite tricky as well. And also in terms of like policy making, etc., etc. So perhaps the first question for Michelle, as an in-house employment lawyer, what kind of things have you seen or experienced that create risk and result in issues falling between cracks?
Thanks, Joyce. So I think the biggest issue that I have seen that leads to further issues happening and things falling between the cracks really is a lack of communication and cooperation. I found that good communication really is the easiest way to make sure the organization is covered from an employment legal perspective. In my experience, it's very useful if at the outset you can delineate between what HR does and what legal does. The worst situation you can be in is where something comes in and HR thinks legal is dealing with it and legal thinks HR is dealing with it. And then you either miss a deadline or it doesn't get dealt with, and then that leads to further escalations. That also ensures that absolutely everything is covered. You have, two buckets, one for HR, one for legal. There should also be a protocol on how HR and legal can work together. So for example, what gets escalated to legal, what can HR sign off on? Does everything that HR produces has to go through legal? For example, I know of one situation where HR asked legal to review a letter that they wrote. That in itself is fine. However, the letter was actually an administrative letter that was being sent to a private members club for which the organization had corporate membership as a benefit for employees. And the letter was about the return of a car park label. Like, I don't think that is something legal necessarily needs to sign off on, and it's not a very good use of everybody's time and resources. So having that clear delineation, in that particular case, maybe the head of HR could have signed off on it, or an internal HR process as opposed to involving legal. Generally, HR teams will deal with the more employee-facing side of things, policies, documents, training in some cases. Depending on how the organization is set up, HR may also play a role in relationships between managers and employees, general counseling kind of. In some organizations, there may be an ER, employee relations function, that may carry that out. HR may also have an investigative function, so they may look into complaints around discrimination, sexual harassment, that kind of thing. But again, in some cases, that may be done by ER, the organization is set up. On the flip side, in-house counsel, employment counsel generally take on more of a counselor role. So things like keeping up to date on the law. You mentioned changes around COVID. In the last few years, we've had changes to discrimination laws, the Employment Act, MPF, all of that. So staying on top of that, making sure everyone's aware, running appropriate training, mitigating and identifying risks. Legal should also be mandated to ensure the organization takes appropriate steps to protect itself. So whether that be, as I mentioned, training, for example, in the sexual harassment or discrimination situation, but also making sure documentation, templates, et cetera, are all up to date. Only, I think, by working closely together, really can the organization be protected from an employment legal perspective.
Maybe I will have a follow-up question for Michelle first. How about when legal is being brought into a matter at a very late stage? Have you ever seen that kind of situation before?
Yes, and it's very messy.
Anything that you think can help to avoid that?
Really getting legal involved at an early stage can help shape how the matter goes. There have been some situations where HR have made a decision, or the business has made a decision, HR have executed that decision, and it's not been done in a way that recognizes the risks or takes them into account. And so by the time it lands on my desk, it's this big, steaming, hot pile of poo, and it's really difficult to unravel in some cases. So getting legal involved early, and we can then make a call as to whether external counsel, so for example, Fiona, is needed, because sometimes we need either an extra pair of hands or additional guidance on how to steer us, set a strategy. And doing that at the outset, I think Fiona will agree, is much easier than when everything has already been done and it's a mess.
Yeah, thank you, Michelle. I think the theme here is that legal shouldn't be too reactive. Sometimes we need to have constant communication with the HR department. So maybe I will turn to Fiona Lan. As a private practice lawyer, I think you're getting lots of calls from your clients on a day-to-day basis. So number one, what are the frequently asked questions that you've got? And what's your observation on how the relationship between HR and legal could actually affect the outcome?
Thank you, Joyce. Thank you, Michelle. Goes without saying, I think, but I agree with everything that Michelle has said. Getting legal involved early, and this is to your second point, Joyce, so just comment on that at the outset. Getting legal involved early doesn't mean that HR or ER are handing the matter over to legal. Sometimes just a 5-minute input or skim from Michelle or from external lawyers will be enough to flag the issue and to, got very moody microphones today, just knowing that is happening and deciding to what extent you or somebody in your team want to be involved will be enough. But if it's left until the last minute, that can really throw up some problems. Joyce, you asked about spending time on the phone and frequently asked questions. Yes. The thing about employment law is that it's often urgent. Things, hiring, firing, those sort of things can't really, wait until next week. So yes, I spend a lot of time on the phone, and the lawyers in the group spend a lot of time on the phone. A list of frequently asked questions would be really long, but just to take some sort of typical examples, the sorts of things that Michelle and I have to deal with. I'll start with hiring and firing. Sounds kind of basic, but notice periods, you specifically mentioned notice periods to me, and I agree. You'd be surprised how it's possible to get the assessment of notice periods or the calculation of the payment in lieu of notice wrong. For example, you might be laying off a team, and some of the team are in Singapore and some of them are in Hong Kong. Hong Kong changed its law in 2007, I think, to set out a new formula, different formula for calculating payment in lieu of notice based on a historical backward-looking calculation. But previously, the formula was what the person would have earned. And there's a piece of litigation over that. And as a result, the formula was changed. But in Singapore, and in Singapore nowadays, the Employment Act applies to all employees. In Singapore, they still have the old phraseology, would have earned. So I've seen people get slipping up there where the different formulas, which are legally required in the respective jurisdictions, give rise to different results and different treatment of team members. So another thing that I think you were interested in, Michelle, was garden leave and whether there's a right to put people on garden leave. I think whenever you're in a situation where somebody's going on garden leave, either because they're resigning or they've been let go, but for various reasons you don't want to release them to the market just yet, you do need to consult legal, because it cannot be assumed that there is a right to force somebody to go on garden leave. And I remember a client, a non-Hong Kong based client, some years back, many years back, being quite surprised and quite upset when I told them that garden leave, they'd been relying on the fact that they could put somebody on garden leave, and they hadn't wanted to have restrictive covenants when they were setting up their contracts long before lawyers were involved. So they had these contracts without restrictive covenants, but a long notice period in Hong Kong. The employee and the new hire, the new company hiring them, the competitor typically, can buy out, and there's absolutely nothing that the current employer can do about that. So that would be an example of the example of contracts being put in place without understanding all of the local implications. And I already gave you an example of how the considerations can differ place to place in the Singapore and Hong Kong notice provision. Okay, and I briefly mentioned restrictive covenants. I'm pretty sure that ER and HR would usually involve legal in drafting of those, but what about enforcement? Is it a good practice to pay somebody for restrictive covenants? The legal answer to that varies jurisdiction to jurisdiction. There's been a case on that in Hong Kong recently. Generally, I think it's an area where legal can be very useful to the business and useful to ER in terms of keeping education going. And then discrimination. Did you have a question? No? Discrimination. I know I'm rattling through what might sound like a sort of one-to-one on employment law, but these are the sort of things we get asked about. Discrimination is really important. Hong Kong's a bit of an outlier in that it has developed a very decent body of meaningful anti-discrimination laws, and it's had those in place for 25 years. So it's different from most Asia jurisdictions, excluding, of course, in APAC, Australia and New Zealand, which also have very developed, mature anti-discrimination laws. Hong Kong does have a body which most of you probably know this, but just to recap, there's about 7 different things which are protected, including race, gender, pregnancy, sickness, and family status, marital status, and recently breastfeeding. So it's very, very important indeed that these laws are taken into account and that everybody understands them, not just the people in HR and ER, but the businesses, everybody. In fact, it's extremely good practice. It's not quite a legal requirement, but it's very, very strongly recommended that education and training is given regularly, annually, to people who in your organization. We give this sort of training. The EOC gives this sort of training. I'm sure you do something in-house. It's a legal requirement in certain jurisdictions, such as New York. Not a legal requirement here, but very strongly recommended. And why? Because you don't want to be the first bank or the first TMT company or the first company in Hong Kong, which is going to be on the front page as having been stuck with a judgment against you for sexual harassment or pregnancy discrimination or disability discrimination or something like that. Quite apart from the legal exposure, there's a huge stigma and reputational risk attached. So again, I think that's an area where it's really, really important that everybody talks to each other. And then I'll stop in a minute, but...
Thank you, Fiona. I think you've sort of gave us like a Employment Law 101 for Hong Kong, and then from corporate perspective about the reputational risk that may be involved in the HR issues. I think another sort of quite frequently asked questions will be about termination and dismissal, which can be quite tricky as well. If not handled properly, can also be a reputational issue for the corporate. And there are so many reasons that from the business perspective, management perspective, that they will like to dismiss someone, terminate someone, fire someone. But then there must be a legal ground. It's not because, oh, I don't like this person or because the performance is not great. There should be like a process, legal grounds to do so, right? And sometimes mutual separation can be considered as well. So any advice on that, Fiona?
Well, I would challenge you slightly there because this is a gathering of Hong Kong lawyers. And it's still legally the case in Hong Kong that you don't need a reason to dismiss. What you do need to do is make sure that none of the prohibitions and restrictions apply. And you also need to make sure that there is no ground for dismissal in play, which could be said to be discriminatory. But provided the person is not on maternity leave or hasn't given notice of intention to take maternity leave, provided they're not on sick leave, provided they haven't had an accident at work, and provided there's no nexus with a discriminatory ground, for example, dismissing somebody because they're taking time off too often to go on maternity leave, or something like that, then you are generally okay to dismiss somebody as long as you pay them the requisite amounts. Now, of course, there will be occasions where summary dismissal is justified, and that forms an exception to the prohibition on dismissing somebody who's on sick leave or on maternity leave. But leaving aside cases of summary dismissal, which, as many of you will know, can be really hard to justify in the courts in Hong Kong and similarly to elsewhere. Leaving those aside, generally, as long as you take care not to fall into the traps that I've mentioned, you will be able to get rid of somebody. Now, of course, the organization may choose to go through a process, right? That's very common. And I'm not saying that you shouldn't do that, but just we're here to talk about law rather than good practice. If an organization has chosen to give a commitment to its employees that they will not dismiss without going through a grievance procedure or a disciplinary procedure or something like that, then that kicks in. And of course, that must be taken into account. But the legal position is that Hong Kong is still a pretty employer-friendly place in which to operate. I can see somebody in the audience really frowning as if they disagree with me, but feel free to send a question or make a comment if you wish. I think you also wanted me to say something about separation agreements.
Yes, mutual separations. When should it be considered and negotiated?
Yeah, I mean, this ties in with what I was just saying. Hong Kong continues to be an employer-friendly place to be. And I'm not sure that it's always wise to adopt the approach that you must have a separation agreement. But a lot of the American clients we work with, American-based clients, take the different approach, and they will always have a separation agreement. But, you know, you need to proceed with some care. You don't want the employee, and I hope I'm coming across as employer-friendly, but I am employer-friendly. I act for corporates, not individuals. And so I often caution the corporate clients, you know, don't make the guy think, or the person think, that he or she has got legal rights. Hong Kong is Hong Kong. This person may not understand that, particularly if they've come from a different jurisdiction, but provided there's no discrimination, and provided none of the employment ordinance restrictions that I mentioned apply, then you can separate. Now, of course, many of you in this room will act for clients or work within clients where there is a practice of paying people, you know, severance when they go. And of course, that is a good thing. An amicable separation is a good thing to achieve. People come back. You've got reputations to think about in the market. And of course, if you're giving somebody something extra over and above the legal entitlements in Hong Kong, then there should, of course, be a separation agreement, just for peace of mind, to know that the line has been ruled underneath. And it should include all the good things about non-disparagement and confidentiality and reaffirmation of restrictive covenants and so on. Another example of how HR or ER could benefit from involving legal is that I think only the lawyers sometimes understand the value of getting the restrictive covenants reaffirmed at the time of separation. It's much easier to enforce restrictive covenants that are given in the context of a departure and a separation agreement than those that are given when a person joins. So that's something to think about as well.
Any other points that we should note when we are negotiating the mutual separation agreements? Anything like privilege, anything like that we need to take care of?
Yeah, I mean, privilege is something that I think is, you know, sort of obvious. There will be times when you want discussions to be privileged. You want the discussions both internally and with the individual. And that is, again, another reason for involving legal. I don't think need to go over with this group how you create privilege, but just remind that it can be easy to lose privilege by a careless communication being exchanged, maybe between the business, you know, discussing something and making a comment which could be discoverable in the future, or have to be provided pursuant to a data access request.
Yeah, I think Fiona's sharing is very, very helpful and useful, because I think not all of us in our corporates, we have the luxury to have Michelle as a dedicated employment lawyer, but we have like the words of advice from Fiona today on some points to note, some guidance, some pointers here in terms of handling some tricky HR issues in the corporate. And then turning to Michelle, we talked about like personal data in the first session, and I think personal data is also one of the very important part in HR, and perhaps even in dismissal, termination, etc. So any views on the handling of personal data in such circumstances?
Yeah, so one point Fiona mentioned just now was data access requests. So these I have seen used quite a bit in contentious termination. So where you have an unhappy separation, data access requests can be used by the individual as a tool to almost do some pre-litigation discovery. Technically, it's not supposed to be used in that way. The guidance provided by the Privacy Commissioner says it is not to be used for phishing purposes. Unfortunately, if you suspect that it is being used for phishing purposes, that is not a ground to refuse to comply with a data access request. So, And this is where communication between HR and legal is incredibly important. Data access requests have to be complied with within 40 calendar days, not working days, calendar days, so just over a month. And in some organizations, you may have a dedicated privacy team. If not, then legal have to handle it. And it's very important that HR and legal, or the privacy team, all work together to gather all that information. Depending on the organization's size, record keeping, this may actually take quite a bit of time. It also depends what the individual is looking for. Often we'll see a request for employment contracts, correspondence, termination letters, pay slips, appraisals, notes around decisions to terminate, notes around bonus payments, anything like that. And they do it under the guise of personal data. And often they're gathering information, and this is not always the case, but often they're gathering information to bring a claim in the labor tribunal, the EOC, various other places. So it's very important that you stay on top of that. And that's where communication really is key. And also from a legal perspective, it's also very important that as part of that exercise, that the organization has complied with the PDPO as well. So in terms of guidance, the DPPs, data protection principles, all of the collection, storage, use, all of that. Because if someone asks for information and the organization is supposed to have it but doesn't have it, that could also be a problem.
Thank you, Michelle. Perhaps I can also throw the next question to you, Michelle. Any suggestions to improve collaboration between legal and HR and to maximize the resources? You talked about communication, but how can we improve that on a daily basis?
Yeah, so I think really the key point is communication, delineating tasks, making clear what is HR's remit, what is legal's remit. And I think from an HR perspective, making very clear what they run with, and then making very clear what legal run with. So from an HR and ER perspective, for example, they will often have the skill set to deal with employees directly. For example, in my role, I don't necessarily deal directly with employees. For example, day-to-day redundancies, I don't personally carry them out. That would be for HR. So that's their skill set. And also for internal investigations, often HR and ER may be better placed to run them. They're more aware of the actual process that they have to go through. There are various hoops that need to be jumped through to follow your own investigation process. And they will have the information at their fingertips. They can access the employee personal data, the P files, contracts, all of that, that you may require. And also company policies, adhering to contractual documentation, that should all be within HR's remit. And HR should also be the owner of HR documentation. Legal can review and help update, but really it should sit with HR. Obviously, it will depend on how the organization is set up, but I think the best way to maximize resources where you may have a very lean team, both in legal and in HR, is to make it very clear who is doing what. And then that also goes back to the question of risk and how to minimize risk and make sure nothing falls through the cracks. Because something comes in and HR know they run with it. And if they need legal input, they come to us. Something else comes in, like from the labor tribunal, that lands on my desk and I handle that, not HR, for example. Fiona, what about from a legal perspective? What would you say the legal team would be in charge of?
Well, I completely agree that clear demarcation of responsibilities is absolutely essential. And even within the HR team, the ER team, and legal teams, obviously, working out and identifying and putting on record who's responsible is very, very useful. I agree with what you've said in your broad discussion of what the difference in responsibilities would be, broadly speaking. I do think it's good to have somebody in the legal team who's responsible for giving regular legal updates to HR and payroll. I mean, I mentioned earlier the formula for calculation of payment in lieu of notice changed, but in fact that change to formula impacted on all statutory payments. And you would be quite surprised that a number of employers took some years to play catch up with that change, which resulted in a problem for some of them because they had to make back payments over a few years and so on, and explain the disparity to the Labour Department and to their employees. So I think just somebody taking responsibility for looking what has happened in the last quarter. Is it something that I need to get a little roundtable discussion going on? I think that's a good idea.
Have you come across situations where the HR team, they have changed, like new persons joining the HR team, and then they're asking the same questions all over again? Any way you think it will improve that situation? How to tackle that?
So I'm going to go back to this point about communication. So it's not just communication with legal and HR, but communication within HR themselves. One thing that when I joined the bank, I worked very hard with HR to get them to talk to each other. HR professionals often have a wealth of experience, whether within the bank or your organization or their prior organizations. And so if they talk to each other, they may find that someone else has had the same situation, or that someone has come up with a very creative solution to the same problem. So in my first 2 months, I was getting the same question every week from different people, and getting them to talk to each other and create their own knowledge bank really helped. It's especially true where you have a large organization and lots of HR people. Just reminding them that they are their own knowledge bank can be very helpful. But I'm sure, Fiona, you get the same. Clients calling you about the same thing all the time.
They do, and we have to remember. I hope you can hear me. I think there's some problem with one of the mics. Yeah, we do, and we have to be very careful. We don't want to charge a client. We're not going to charge a client for advising them on the same thing twice. So we have to, remember what we've advised on before. We have to monitor it. We have to keep records, obviously. We have to make sure we advise in the same way. We've got quite a big team, and some questions are really easy to answer. There's a black and white answer, and sometimes there are nuances. And, that's part of why I like employment law. I didn't start off life as an employment lawyer, but I like the nuances. I like the interpretation. But we have good communication within our own team, and we often talk about these gray areas. And sometimes we will even acknowledge to the client, Sarah thinks this, I think this. The court could go either way. So, yeah.
Thank you, Fiona and Michelle. Michelle actually mentioned something about incident handling, and usually there's a process, the HR should be running the process, but then it usually happens in a very high pressure environment. And as I mentioned in my introduction, legal may be brought in at quite a late stage. And often in the internal units, for example, senior management, legal, HR, they may take different views on things and may have different risk appetites. So in handling this kind of situation, what's your view as to where legal should stand, whether we should take the lead or in terms of decision making? The process should be run by HR. You mentioned about that, but how about the decision making?
So I think it's very important for legal to be involved in the decision making. Both to provide legal advice, but to assess the risk. But I think the ultimate decision will often rest with business. It really depends on what the issue is, but it will more often than not involve a sum of money and or, for example, the termination of an individual's employment. And it is for the business to decide whether they are happy to pay that sum of money or to forego that resource if they are going to terminate an individual. So I think legal's role in that is to provide support, but to make very clear what the legal position is, but then what your options are. So looking at the end goal, if the end goal is to terminate an individual, it's almost like working backwards. You say, okay, we can terminate under the law, as Fiona said, relatively easy to terminate. Check there are no discriminatory issues, they're not pregnant, on sick leave, etc. And then work backwards from there to see how best to execute to get the business to where they want to be, but also respecting the risk appetite. If they need to pay a sum of money, how much their ceiling may be. If they ultimately want to keep the person, how you navigate that.
Fiona, any experience sharing here? I think you're getting a lot of this kind of...
no, it's great. We're singing the same song, Michelle and I, unsurprisingly. Just one thing to add. Both of us have stressed to you that Hong Kong is an employer-friendly jurisdiction. Both of us know that, and that's good for our corporate clients. But you do need to make sure that there's no nexus with a different, less sympathetic to employers' jurisdiction, right? And I think that the last year or so has seen a big increase in the risk of a different law applying simply because of the practice of remote working. You know, we all know people who took off from Hong Kong some time ago for a short trip and didn't come back, or just have kept something open-ended. And some of those people have now been working in those jurisdictions long enough for tax consequences, personal tax consequences to be triggered, corporate tax consequences to be triggered. That's another risk, another topic. But most of all, if somebody stays long enough in a jurisdiction where your client, particularly if it's a jurisdiction where your client has a presence, then there could be, depending on the detail of the arrangements, substance to the argument that that person has acquired protection under, for example, English law, a right to claim unfair dismissal, which doesn't exist in Hong Kong. Australia is another place that has a lot of protective laws. Korea, Japan, Germany, France, all these places. So that's something I would add.
Thank you, Fiona and Michelle. You just talked about COVID, so perhaps let's turn to the COVID situation. So it's been going on for 2 years, and many corporates has adopted different policies. Some of them has adopted return back into the office, and some of them they have chosen to adopt a hybrid mode, so the employee may choose to come back into the office or work from home. But then here it comes the issue from HR perspective, whether from corporate as an employer can force the employee to just do one way or the other. Oh, you must come back into the office, even if the nature of work of that employee permits to work from home. But whether the corporate is entitled to force the employee to do one way or the other. Then when it comes into the policy making of this type of things, it's not just about the legal requirements. There are also the employee sentiments. Oh, I want to work from home. I prefer to work from home. So how do you balance that kind of like different interests and the legal requirements? What's your view? Fiona, Michelle? Fiona?
I'll start and then you can add. A huge question, and it's definitely on the list of frequently asked questions these days, although that will not continue forever. Do employers have a legal right to demand people to come back? They probably do, because the terms and conditions of employment will probably say your place of work is our office, our Hong Kong office, or wherever the office is. And although that has been varied for the life of the pandemic and restrictions still in place in Hong Kong, much less so elsewhere, although that has been varied, I'm pretty optimistic. I'm pretty sure that the courts will take the position that that was not a permanent variation. That was by nature of a temporary concession, which was required by the circumstances. Yeah. So that's my view on that particular question. In terms of balancing, that's very difficult indeed. There are lots of things to take into account, and one of them is retention. There is a war for talent. There are jobs which employers are finding it very difficult to fill. You may want, let's say the employer's policy is, or preference at this stage, is that most people are back in the office, or they're back in the office for 4 days a week, or something like that. But there's a key team, a really important team, and they like working from home. A lot of people do like working from home. A lot of people don't like working from home. It varies company to company and place to place. I mean, I think if I lived in the UK, I would probably be much more keen on working from home because I'd probably have a commute. Here, I'd much rather be in the office. So a lot of things to balance.
Yeah, I agree completely, Fiona. It's dealing with the second half first. The employee sentiment is very hard to gauge because everybody wants something different. And so It's also finding a balance with what works for the organization. I completely agree with Fiona's comments that the starting position is everyone is back in the office because your contract says so. And that the COVID variation was not a permanent variation, it was due to circumstance. But obviously, the argument then comes back of, well, I've been working from home for the last 2 years. Why can't I continue to do so now? And so finding that balance, because if you have everybody working from home, you lose that community spirit and community feel in the office. What happens to Friday night drinks? You know, there's one person and a bottle of wine. But you also have to recognize that people want that flexibility. So it's a very hard balance to reach. And I think as an organization, you need to get a feel for your employees. So do a survey, ask around, speak to people, but then also work out what works for you as an organization. There are going to be some roles that you just can't do from home. There are going to be some roles that you could do 100% from home, but you have to put in some consistency. And you're never going to have everybody 100% happy. Someone's always going to complain about something. So you do the best that you can, and ultimately what works best for the organization.
Yeah, I think, thank you, Fiona and Michelle. This is a big topic that we've been thinking about. I think many corporates have been also thinking about the best approach for themselves. And I think there's no easy solution, but just number one, of course, the legal requirements, and number two, just understand and communicate, not just with the HR department, but with also your employees, just to understand more what they want and more communications there. Another hot topic about technology. So I think there are lots of use of technology nowadays in the HR process, recruitment, hiring, etc. So there is a standardization on processes, which is a good thing, right? Making things more efficient. But then does it help with the alignment between HR and legal? Or do you think with everything now online, legal is being left in the dark even more? What do you think? Maybe Michelle is an in-house.
That's a good question. I don't think legal's being pushed out or behind, as it were. But I think if the organization is going to implement online processes or, automatic processes, legal should be involved, because it means that, for example, you have someone fill in an online application or do an online questionnaire. Legal should go through those questions, make sure there's nothing discriminatory. We're not asking people, do you plan to get pregnant in the next 6 months? And various other things. So we can build in some protections. And so I think legal plays a very important part in that. And automating the process, I think overall will be a good thing. It's more efficient, time efficient, resource efficient. But I don't think that means that, legal takes a back seat.
Perhaps one last question from me before we open up for the Q&A from the audience. So I can pick up the common sort of traps that you both mentioned is about discrimination. So anything that you can share more with us? What from an in-house lawyer perspective we need to take care of when the HR comes to us on certain occasions, for example, like the questions that we briefly touch on, whether we can dismiss someone where he or she is on sick leave, a long-term sick leave, and then all the statutory leave has already been utilized, then whether we can dismiss that person because there may still be a discrimination issue, anything like that you can share in your experience. Some free advice here, Fiona?
Sure. Shall I go? Yeah. Yes, you should all treat these types of seminars as an opportunity to get free legal advice. Yeah. This is unfortunately quite a common scenario, a reasonably common scenario in the sort of things that we get asked about. Joyce has described the situation where somebody is on sick leave, they use up the statutory sick leave. Can you then dismiss them? So the way I always describe it to overseas clients who might not be familiar with the Hong Kong law is there's the first level, the absolute prohibition in the employment ordinance. You cannot dismiss somebody as long as they are entitled to statutory sick leave. Statutory sick leave is really generous in Hong Kong. It's surprising. In New Zealand, I think you get, last time I checked, I was comparing this with somebody at a conference, I think you get 2 weeks of paid sick leave. Here, you accumulate 2 days of sick leave during the first per month. during the first year of service and 4 days thereafter, up to a rolling maximum of 120 days. And that's probably 120 working days, not calendar days, depending on how you administer your payroll. So once you get to the end of that statutory sick leave, if the person comes back to work, then he or she can then dip into the days that have accumulated during the statutory sick leave. They continue to accumulate. But if they don't come back, or sooner or later the days run out, what then? It's very difficult, because if you do get rid of somebody in those circumstances, there's almost an inference that it's because the person is on sick leave. And if the disability, the sickness, known as disability for the purposes of the Disability Discrimination Ordinance, is even one small part of the reason for selection, then you're guilty of discrimination, the manager who makes the choice or the employer. So it's something where you have to proceed with great care. If you're making a whole team redundant, including that person, that would be different. But if you're not, then it's not an easy situation to resolve.
Yeah, completely agreed. And I think one other point to bear in mind is the reputation risk. You have an individual who has been on long-term sick leave, which normally means they're very sick, and then to terminate them, albeit while they're not on statutory sick leave, but probably still quite ill, is not a great look.
Perhaps I can follow up with a small point here. So whether from an employer perspective, as an employer, we are entitled to access the medical records of the employee in such situation? I think there are some personal data issues involved here.
Yeah, only if the employee agrees, has to give their consent. And I would make it very clear when you seek that consent that you're only going to use the information for the purposes of whatever you're going to use it for, assessing whether they can require accommodation, for example.
Thank you. So let me open up for the audience for Q&A. Any questions from the physical audience here in the venue? Or maybe we can answer the questions from the online Q&A. So it's about restrictive covenants, whether we can impose, as an employer, impose restrictive covenants during the course of employment or at the point of termination, or whether all restrictive covenants must be renegotiated prior to the signing of employment contracts.
Easy question to answer. Yeah, hope you agree. Be fun if you didn't. You can impose restrictive covenants at any time, but you must make sure that there is consideration for them. And that's why usually they're included in the original offer. Some clients will renegotiate them and reimpose them and get an affirmation. Remember, I mentioned affirmations earlier on in the context of separation agreements. Some clients will get people to reconfirm to them when they're promoted or periodically as a condition of receiving a bonus. And why would you want to do that if you already have them in place? The reason is that the reasonableness of the restrictive covenant is assessed at the time of at which it's given, not years later when somebody departs. So somebody could be hired as a 2-year out salesperson, very junior. They're asked to enter into restrictive covenants. For a 2-year out junior salesperson, a 6-month or 12-month non-compete is not reasonable, but the person does really well, becomes very senior. If he or she has been asked to re-give the restrictive covenants the previous year when they were promoted, then you will have a much better chance of getting enforcement.
Yeah, completely agreed. And because you need to, restrictive covenants should be tailored to the role, to the person. So very much to Fiona's example, you could have a very senior individual who has a restrictive covenant from when they first joined, and it wouldn't be appropriate. So very much agreed.
And definitely put them in a separation agreement. I mentioned that earlier because it'll hugely increase your chance of enforceability.
Thank you. And there is one more question from the Zoom Q&A. Are termination service useful after termination? Any insights, any experience?
That's a good question. I guess it depends how honest people are feeling, because they're only useful if someone is actually honest. But if someone doesn't want to give you feedback or is scared to give you feedback, and this is where non-retaliation policies come in, non-victimization, et cetera, then you're not going to get any useful information. So I think you can try, And I think most organizations will do some kind of exit interview or termination survey. But as to their usefulness, it depends the data that you get.
I'm being mindful about time. I can see that questions still coming in, but I'm being mindful about time and your lunchtime. So I would like to call it an end to this session, and thank you one more time to Fiona and Michelle for your very insightful and honest sharing. Please give a big round of applause to Fiona and Michelle. Thank you.
Thank you all. Would our panelists please stay, as we would like to present your souvenir. May we invite our Vice President, Mr. Roden Tong, to come onto the stage and present the souvenirs for us. Roden, please. Let's take a group picture. Thank you. That's all for the morning section, and we will return at 2 p.m. after the lunch break. If you're not joining us in the afternoon, thank you for coming, and I shall see most of you again at 2 p.m. Thanks.